Hello, and thank you for joining us today on the Ask Andrew Show, Canada's first Facebook live streaming family law question and answer show. My name is Andrew Feldstein, and I'm the principal of the Greater Toronto Area family law firm, Feldstein Family Law Group. We have offices in Markham, Vaughan, Oakville, and Mississauga. Both myself and our entire firm practice exclusively in family law in the province of Ontario. Today, we're doing something different that I think we've only done it once before, and we're having a special guest that's one of the associates here at Feldstein Family Law Group, Mr. Jeff Hart. Thank you for joining us today, Jeff.
My pleasure. My pleasure, Andrew. Happy to be here.
Well, welcome to the show, and I want everyone to understand that Jeff has a plethora of experience in family law cases dealing with custody, access, property support. He's dealt with all areas of family law, and in particular, Jeff is, I'd call him the go-to person in this firm for Children's Aid Society work. So Jeff does most of the Children's Aid work. And when we're dealing with files that are not before Children's Aid and there's issues with Children's Aid, everyone usually goes to Jeff for advice. And that's because Jeff once worked at a Children's Aid Society and is intimately familiar with the legislation as it pertains to societies. And Jeff, starting from there is where I'm going to ask you my first question. What is a Children's Aid Society?
So a Children's Aid Society is a nonprofit organization with a very large mandate, effectively to assist families and children in any issues they see in respect of any problems that a child might have in respect of their care or their mental health. It's a very broad mandate. They're funded by the province of Ontario, so it's a provincially funded organization. They operate under a provincial statute, which is called the Child, Youth, and Family Services Act. And I admit I had to look this part up. There are 46 in the province of Ontario. They're usually grouped by municipality or by county. I actually didn't realize there were that many, but there are apparently 46 in the province of Ontario.
Now, I know when you say there's 46 in the group by municipalities, some are also grouped by religion as well.
That's right. Yeah, I've dealt personally with Jewish family services. There are two agencies in Toronto. There's the Catholic agency, and then there's the Toronto agency, and there's also Jewish family services in Toronto as well. So I also know that there is a native, at least in the Toronto area, and probably I would guess somewhere where there's a larger native population. They're also grouped by First Nations and by Indigenous populations too.
Okay. Now, one of the questions I sometimes ask, I hear from my clients, is they ask, what is the difference between Children's Aid Society, CAS, and the OCL?
Okay, so broadly, the difference is that OCL is a government agency, an offshoot of the Attorney General, and they can represent children, as OCL counsel can actually have children as clients, whereas CAS is not a government agency. They're funded by the government, but they're not an actual government agency, and they don't represent individual children. Their mandate is to protect children sort of as a large group, but they don't represent children, but they represent their interests.
Okay. Now, understanding that background, do you sometimes have the Office of the Children's Lawyer involved in CAS cases as well?
Very often. It's sort of, they're complementary. I mean, when I was CAS counsel, I found it very helpful, especially with older children. Now, I would say routinely from about age 12 and up, we sought the OCL involvement because the older a child, generally, not just in child protection law, but in family law too, the older the child, the more weight a court would give to their views and preferences, and the best way to get those views and preferences before the court would be to assign them counsel. I only ever ran one trial as a CAS lawyer, and thank goodness I had an experienced OCL representing the children in that case. It was an excellent team. We were an excellent team together.
Okay, now I think of a family, and usually it happens when they're going through a divorce or separation, and they're one of my clients as an example, or any of the lawyers' clients here in this office. and they phone my office and say, my spouse called Children's Aid Society on me because they're accusing me of doing some awful things to the kids. And that's a fairly common question. I assume you get that in your practice as well.
I do, yeah.
And the question I'm always faced with is, what do I do when CAS calls me about these false allegations my spouse has made about me? And I know sometimes I come to you and I talk to you about those allegations and even put you in touch with my client, but how do you respond to that question?
Well, as a general rule, I mean, usually all the time, in fact, my first piece of advice is have the client, have the particular person that's accused of something to cooperate fully with the CAS. Nothing will get them acting against you and in a more intrusive fashion than trying to avoid them or brush them off. The best way to do it, the best thing to do at the beginning when they're first involved, when you find out that an allegation has been made, is to immediately do your best to reach out to the CAS worker, the child protection worker, or the intake worker, whoever it is that reached out to you. Tell them that you're available to them whenever's convenient for them, and you have to move your life. If that means you have to move your life around, then so be it. But it's critical to be not only to engage with them, but to be seen to be cooperative with them. And frankly, since they have the resources of the state behind them, you're not going to win that fight. And it's just going to be, it's kind of like dealing with the Canada Revenue Agency. If you deal with them and you work with them, they can be okay. But if you try to fight them, you won't win. So my major piece of advice is cooperate fully right off the bat.
Now, I'll tell you, in my experience, usually when people are cooperating fully, as you put it, they've had an opportunity to have a discussion with us before they have the discussion with Children's Aid. And sometimes people have made mistakes. And I think the message a lot of people have to understand is everybody is human. That means, have children been exposed to conflict they shouldn't have been exposed to? Probably. There's nothing wrong, depending on the severity of it and the regularity of it, of sometimes admitting to CAS, and this is something you should speak to your lawyer about before you do, though, but admitting to CAS, yes, I made a mistake. It was a bad time in my life. Something happened. I made a mistake. I appreciate it was wrong. It won't do it again. Because what CAS is looking for, and you're going to tell me if you agree, is whether or not this child is in need of protection from one or both parents. And if they are, what are they going to do about it? And if you're demonstrating to CAS, I know I made a mistake, they're less likely to think the child is in need of protection than on a go-forward basis. Do you agree with that type of characterization?
I absolutely agree. And frankly, courts don't expect people to be perfect. They understand that people are human, people make mistakes. Where you've made a mistake and you've acknowledged that mistake and you've said, yes, I did it, I shouldn't have done it. I understand now that I shouldn't have done it and I won't do it again. And here's what I'm willing to do in order to make sure that that doesn't happen again. Those were the kind of parents that we loved dealing with at the Children's Aid Society. When you acknowledge that you've made a mistake and you are willing to move on, no problem, generally speaking. I mean, don't repeat that same mistake again, obviously, but you won't get crucified, pardon me, for admitting that you made a mistake. Only where you take it as they get their back up and they would see it as a vast conspiracy against them and they would never admit to any wrongdoing whatsoever. That's when the society got really concerned, and that's when the society sort of ramped up their investigation. So I agree 100% with your characterization, and I would I tell my clients now, if you admit you made a mistake, if it was an honest mistake or what have you, and it happened once, admit it, because it's going to come out probably anyway. And if it comes out from you, it's much, much better than coming out from the society in one of their affidavits.
And, I look at it and say there's two ways people can approach a problem. One way is you have the denial, frustrate, delay, hinder CAS. And some people's viewpoint is, well, that's better because they're trying to find me some form of guilt, like they're a quasi police force. And the problem that you're illustrating, and you really can't say it enough to clients when they come in, is that if you do that, like you said, you're putting your back up against the wall and you're putting yourself right in their crosshairs where they're going to want to investigate. They're going to want to dig deeper. They're going to think there's a problem. Versus a client who says, yeah, I made a mistake. I shouldn't have argued with my spouse like that in front of my children. They shouldn't have heard those awful things I said. I blew it that day. And in fact, one of the things I've said to many clients over the years is you even say to the CAS worker, do you have any courses that you think I should take that will make me a better parent so I can learn from my mistakes? I'm happy to take them. And if you're showing that level of cooperation, I see all the time, then you get a letter that's from CAS that says, we've closed our file. There are no child protection concerns, but don't do it again.
Yeah, and that's great advice. I want to say that the society doesn't exist to, they're seen as this boogeyman, the big bad society that's going to swoop in and take my kids away. That's the last thing the society wants to do. And frankly, it's the last thing that the society, the legislation is such that the society is mandated to take the least intrusive option to fix what they see as the problem. And if you've got a parent that's willing to say, yes, I admit I made a mistake and I'm willing to work with you. And hey, have you got any resources that you can send to me and we can work together and I'm happy to fix the problem. That's a dream client for me as a family lawyer. And it's also a dream parent to work with as a society. They much prefer that outcome than having to take somebody to court.
Now, one of the things that happens is you have a couple that is going through a divorce and separation, and CAS is investigating the family at the same time. And what people also need to appreciate is you might think it's a strategic advantage to go report your former spouse to CAS, and you probably have heard people say that before. Mm-hmm. And they don't realize that the moment you pick up the phone and call CAS, they aren't just looking at what your complaint is. Everything's on the table. Everything is fair game. So I think you'd agree with the statement of don't throw stones if you live in a glass house. And it's a perfect example when you start inviting Children's Aid Society into your family's life, you don't know where it's going to take you.
Absolutely. And to your point as well, not only do they investigate the person you're making the complaint about, and they ultimately would probably end up investigating you if you made the complaint, and not just that, but the reasons for it, because they know, they're not stupid. They know that parties going through especially a high conflict situation of separation, it's very common, and I know you've seen this. Parties look for allies in the litigation, right? So they'll go and they'll try to get the other side in trouble with CAS, or they'll try to involve the police. And the CAS is well aware of that. And the courts are well aware of that tactic being used. And so be prepared to you yourself, if you make a complaint against the other side, to be under the microscope. So it ultimately probably won't do you, at best it would be neutral. And at worst, you would end up looking bad because you're the person trying to dig up dirt on the other side when it doesn't exist.
But that has to be contrasted with the fact that the public has a mandatory obligation to report any child that they know is being abused.
That's true too.
So you have a real balancing act that you don't want to look bad for reporting, but if the child is being abused, you have an obligation, as does a teacher, guidance counselor, a doctor, anybody and everybody, ironically, except for the people who do what we do for a living as lawyers. We're the only ones that have discretion in that regard. Right.
I suppose my comment was predicated on, this would be a false complaint or an exaggerated complaint. If there was if you had a genuine concern about the other side as a parent, their capacity to parent, or they're having exposed the child to things the child shouldn't be exposed to, then absolutely call. But I'm only talking about when it's sort of, blown out of proportion, or just a complete put on or a fabrication. That's when you run the risk of looking bad, very bad.
Now, I want to understand for our viewers the intermingling of CAS and a family court action, because frequently what will happen is you have a family court action and a client says, CAS called me and CAS said, I shouldn't be giving my child to the other parent, which would put me in contravention of a court order. What should I do?
Well, sometimes, in my experience, when you want CAS to be involved, they don't, for whatever reason. And sometimes when you desperately do not want them to get involved, that's when they tend to get involved. But in that sort of tight spot where you're sort of between a rock and a hard place, where you've got on the one hand a court order that says, a family court order that says that, let's say, certain access should happen at certain times, and on the other hand you've got a CAS saying to you, this is bad, you shouldn't, we have concerns, we don't have enough concerns to wade into the fight, so to speak, but we're telling you it's a bad idea, that you should that you, if you continued to follow this order, it would be bad. I generally tell my clients, look, it comes down to, if you're concerned enough, then you should protect your children. Because if you just sort of slavishly follow a court order when I know they're deemed to be correct at the time they're made, but things change, and if I would suggest that a significant change, a material change as we would call it, would be the involvement of CAS or even investigation by CAS. So if you've got it comes down to this: if you've got legitimate principled reasons for being concerned, then listen to CAS and do what they say, but be prepared to defend that position in court. And I would say be prepared to take it to court yourself, so that you get out in front of it, so that you are being proactive and taking it to court and saying to a judge, yes, this is the order, Your Honor, but it's not working right now, and I had to come and I had to seek a further order based on the advice that I was getting from CAS. And the courts understand, again, that sort of a parent in a position like that is between a rock and a hard place.
Well, I agree with you that you got to get in front of it with a fresh court order and get at the very least a letter from CAS. But the alternative that I've also seen happen is you write to the other side, if they're represented by counsel, saying that I know there's a court order in place. CAS has said they're doing an investigation. We shouldn't produce the child. Does your client agree? If they don't agree, then you run to court. And if they don't agree, you may also call Children's Aid and say, listen, I've told them this. Because the interesting thing is that, and tell me if you agree with me, could prompt CAS to actually get involved in a more forceful way if that person who has the access is insisting on it, and CAS could then start a CAS court application.
Yeah, that's right. And I mean, again, sort of as a general rule, CAS is used to being dragged into a family law conflict situation, and they're loath to get involved unless they absolutely must. And as counsel, when I was counsel for CAS, I would have workers come to me all the time and say, do we have enough to take action? And you mentioned CAS bringing an application. They would bring a child protection application, which effectively trumps a family law or divorce act application, and can operate to be a stay as against the family law proceeding that's in place. So if CAS does go so far as to get involved and bring what we call a CPA, a child protection application, then the thing is that it's not automatically stayed, but it doesn't take much of an argument to convince a judge that the family law situation should be stopped while the child protection concerns are dealt with, because in order of priority for a court in Ontario, child protection is right at the top of the list.
Which is interesting, because I think some of the viewers, when they heard me say, write a letter to the other side and see if they would consent to not exercising their access, I'm sure some people probably thought that sounded like a crazy idea. Why would someone agree to it? And what you just laid out is really the reason why they would. Because I think if I was being investigated, I'd rather be on the receiving end of an investigation that I hope would be hopeful the file would be closed in a week or two, than having an additional court action of a child protection proceeding against me because I insisted on access.
And it also means that, I mean, to do what you suggest, if you get a letter from a lawyer saying, hey, look, CAS is involved and they're investigating, we're not really sure what's going to come of this, if anything, but just out of an abundance of caution, can we not have the access proceed? Then you look child focused, and you are child focused in that way. If you were to say, look, what's the harm in suspending access for, let's say, 2 or 3 access periods, or however long the society reasonably needs to conduct their investigation. Time can be made up later if you're dealing with reasonable counsel, and you look good because you're being child focused and not, I demand my access. It's not your access, it's your child's access to you. So
and usually the parent who is being investigated already knows that that's CAS's position. Because I find usually if I receive a letter like that, my client has called me and says, Andrew, I had the meeting with CAS. They're concerned with me. They don't want me exercising access. What should I do? And I find usually when a client phones with that kind of question, they don't really want to start paying for another court appearance while the investigation is going on, more court documents to be litigated, and the timelines in a CAS proceeding, according to the statute, are very fast. So the workup and expense may be very quick. So depending on how long CAS's investigation should take, you probably are better off to cooperate than to fight them. Do you agree with that view?
Almost always. I mean, I want to say always. You should always cooperate. And if it turns out there's no there, so to speak, then you're fine. You're never wrong for cooperating with the CAS. I mean, it can become burdensome if you are paying a lawyer and then they sort of get involved and then your matter gets delayed or drawn out because of the CAS doing their job and maybe not doing it fast enough or in accordance with the timelines. But in my experience, it's never a bad thing to cooperate with CAS, and if that means sort of putting your own best interests, keeping in mind that you're not always in line with the child's best interests, and the CAS doesn't care about the parents, really bluntly. They only care about the children. So whereas most parents think that the child's interests are completely aligned with theirs, the CAS doesn't see it that way necessarily.
Well, and the thing people should understand as well, they might think you're not sounding that aggressive. And sometimes people want their family law lawyer to be aggressive, but they don't see the reality of how much money is going to be spent on that CAS case. And by fighting it, CAS is going to view them as not accepting any small mistakes that they may have made. So they're actually far better off to try and get through the investigation and have it closed through cooperation rather than litigation. It'll be far more cost effective and probably far more faster. Now, I see we had a question came in, and the question was, how was CAS alerted to a case?
Okay, so anytime that, for example, the police are called to a domestic dispute, and if the police in their investigation discover that there are children present in the house, even if they aren't right there in the midst of the fight, they are mandated to contact the local Children's Aid Society because there are children there. So it automatically becomes a child protection concern while the CAS investigates, and the CAS will always investigate. What they end up finding might end up being below their level of intervention, but they're mandated to investigate. And something which some people may consider relatively minor, such as we had an argument, we had a verbal argument, our voices were raised or whatever. And if your children are small enough, I mean, even if they're not, but I mean, especially with small children, I mean, they don't know, right? I mean, and it could have an impact. It could have a lasting impact on their emotional health if they hear their parents yelling and screaming at each other. And so that's why the society has to get involved to see if it actually rises to the level of a child protection concern.
Well, and quite frankly, anybody can end up reporting it. A teacher at school could hear a child complaining about what they hear at home or that a parent hit them, and that teacher or principal has an obligation. You also could have a neighbor or friend who might see something. Now, I see we got another question that came in, which is, who authorizes when CAS gets involved?
Under certain circumstances, they always have to get involved, like some of the circumstances that we mentioned just a moment ago. If the police are involved, if there's a report from a third party who's obligated to do a report, if they're concerned, a guidance counselor, a teacher, or what have you. And then, so generally speaking, how it works is that as soon as an investigation is sort of triggered by an allegation, and it could just be somebody on the street, right? It doesn't necessarily mean that it has to be a person in authority. I mean, if you're in a public place and an interested third party sees that a parent, what they think is being inappropriate with a child, then they can call, and they're invited to call. And then at that point, intake at the society takes over, and they follow up with the person who made the complaint. And they sort of suss out the situation and get some more facts. And if on the strength of those facts, they feel that intervention is necessary, they'll go to their supervisor, get some instructions from them, and the supervisor generally will go to counsel and say, here's what we know, and does that add up to enough of a concern that we need to do? We need to take them to court, we need to apprehend, we need to commence an application, or whatever. So it's sort of once the initial event is triggered, it's sort of an internal investigation as to what level of intervention, if any, that the society will undertake.
And sometimes they just want to monitor a family.
Sometimes, and that's probably the most common sort of court order that I dealt with as counsel there, which is what's called a supervision order, and it's as least intrusive as it can be and still be a court order, and it's just sort of listen more or less. I mean, the terms are all completely negotiable and they differ from case to case, but you have to check in with us. You either have to check in with us every so often, or you have to be available for us to check in with you every so often, or you have to bring the kids to see us, or allow us to interview the kids every so often, that kind of thing, just so we can sort of poke our heads in the door and just see that everything seems to be okay, or has gotten better or has gotten worse or whatever, but just to keep them in the loop so that they can monitor the situation.
And when those things are happening, that's a perfect example of when you need to cooperate with them.
Absolutely.
Because that kind of cooperation will have them say, okay, we want to supervise it for 6 months as an example. And if you've done a good job for the 6 months, they'll probably be out of your lives.
Very, very much so. If you follow their guidance and you take their advice and you be proactive and you even look for more services or programs, as you were saying earlier, it looks great when the parent says, are there any other programs that you can recommend that I would take? These kinds of things are the kinds of things that cause the child protection concerns to go away. And once those protection concerns are gone, the society has no more power and has no more jurisdiction and has to leave. They can only stay while there are continuing child protection concerns.
So at the end of the day, there's a real theme that you and I have been discussing, that cooperation works. What we haven't discussed is sometimes you do have a disagreement with the CAS, and sometimes you're going to have litigation. What does that look like?
Well, it's never pleasant. I can tell you the decks are stacked against the parents, and the legislation is written in such a way that basically the society has inherent credibility with the court. And if it goes, for example, by way of an apprehension, as you mentioned, the timelines are really tight. So effectively, the society brings their rough and ready child protection application, which may or may not be amended later, but then they seek to apprehend based on this very serious situation that's going on. They have to, after the application is issued, they have 5 days to get it in before a judge, and then usually, I don't think I ever, as counsel, saw an apprehension or the first appearance of a child protection application as having any other evidence. The judge always only had the society's evidence. The parents almost never had an opportunity to put any evidence before the court. So as you might imagine, that ultimately meant that the society was going to get its order, whatever order it was seeking, even if it was only on a temporary without prejudice basis. But then at that point, the parents are sort of behind the 8 ball, right? Because there's already an order in place, even though it's without prejudice. It's still sort of it's a heavy burden for some parents in that position to marshal the resources to get a lawyer to effectively put evidence before the court and rebut these presumptions or the evidence that the society has before the court that day. So it sort of goes downhill fast from that perspective. And at that point, you need, I would suggest that most people strongly need a lawyer in order to prepare the proper documents required in order to sort of counter the evidence that the society has put before the court at that point.
So we're almost out of time, but we did have a question come in, and I'm going to paraphrase it. But what's an example of why a CAS society would apprehend a child, which means remove a child from the parent's home?
If emotional harm has been proved, if physical harm has been proved, if a child is left alone, if a young child is left alone for an extended period of time. I'm asked this all the time too, like what age is a child okay to be left alone? I would suggest it depends on the child, but 12 for a short period of time, a couple of hours at most. But serious things like caregiver capacity, like a parent or both parents are impaired by drugs or alcohol or mental health issues or what have you, and there's significant neglect or there's significant physical or emotional or mental abuse. or just the place, the house or the apartment or wherever the child is living is unsafe for the child. That's a few of the reasons. And just thinking back to my time as counsel, those were the kinds of things that caused us to swoop in, and that society would look into placing the child with family first before they'd go to foster care and before they'd have to go to apprehension. And it's only after all those things weren't options that they would swoop in and have to apprehend.
Okay, well, Jeff, that was very informative, and I wanted to thank you for being on the show today. It's 1:30, and we're past 1:30. Actually, we're out of time. So it was a pleasure having you. For anyone interested in learning more about Mr. Hart, you can visit our website at separation.ca. The next Ask Andrew show is on December 12th, 2018 at 1:00 p.m. If you have any requests or show ideas, please email them to us at info@feldsteinfamilylaw.com, and thank you for watching.